Hello, and thank you for joining me. I'm Jamie Johnson, an estate planning attorney in Virginia. Over the years, one of the most common questions I hear from clients is this: do I need a will, a trust, or both? It's a great question, and today I want to help you understand the key differences between these two essential estate planning tools so you can make an informed decision about what's right for your family. Now, I want to be upfront with you. There's no one-size-fits-all answer here. The right choice depends on your unique circumstances, your goals, and what matters most to you, but by the end of this video, you'll have a much clearer picture of how wills and trusts work and when each one makes the most sense. Let's start with the will. It's probably the estate planning document most people are familiar with. A will is a legal document that expresses your wishes about how your property should be distributed after you pass away. It also allows you to name an executor, the person who will be responsible for carrying out those wishes. And importantly for parents, it allows you to name guardians for your minor children. Here's something important to understand. A will only takes effect after you die. It has no power during your lifetime, and when it does take effect, it must go through the court-supervised process called probate. It is a common misconception that if you have a will, then you don't go through probate. The probate court validates the will, oversees the payment of debts and taxes, and ensures your assets are distributed according to your instructions. Probate isn't necessarily a bad thing. It provides important legal protections, but it does take time. It involves court costs and fees, and it's a matter of public record. Anyone can look up a probated will and see exactly what you owned and who inherited it. Now let's talk about trust. A trust is a legal arrangement where you transfer ownership of your assets to the trust itself, which is then managed by a trustee for the benefit of your beneficiaries. I know that sounds a bit abstract, so let me break it down. When you create what's called a revocable living trust, which is the most common type for estate planning purposes, you typically serve as the trustee yourself during your lifetime. You maintain complete control over your assets, and you can change or revoke the trust at any time. And since you are the initial beneficiary of the trust, it's as if nothing has changed from a practical standpoint. But here's where it gets interesting. Because the assets are owned by the trust rather than by you personally, they don't have to go through probate when you pass away. Your successor trustee, the person you've named to take over after you, can distribute the assets directly to your beneficiaries according to the trust's instructions without court involvement. This means the process is typically faster, more private, and often less expensive than probate. Your family's financial matters stay private and out of the public record, so let's summarize the key differences. First, timing. A will only takes effect at death, while a trust can operate during your lifetime and provide for your care if you become incapacitated. Second, probate. Assets passing through a will go through probate, while assets held in a trust generally do not. Third, privacy. A probated will becomes public record, while a trust remains private. Fourth, cost. Wills are typically less expensive to create initially, but trusts can save money in the long run by avoiding probate costs. And fifth, complexity. Trusts require you to actually transfer your assets into them, a process called funding the trust, which does require some ongoing attention. So when might a will be sufficient for your needs? A will-based estate plan often works well for people with relatively straightforward situations. If you have a modest estate, say less than $100,000 in probate assets, if your assets will primarily pass to a surviving spouse, or if privacy isn't a major concern, a well-drafted will may serve you perfectly well. Wills are also essential for naming guardians for minor children, something a trust cannot do. So even if you create a trust, you'll typically still want a will, or at least a nomination of guardians in place for this purpose. On the other hand, a trust-based estate plan often makes more sense for families in Prince William County. If you own real estate in multiple states, say a condo in the Outer Banks or Ocean City, a trust can help you avoid the need for probate proceedings in each state, which can be a significant time and cost savings. Trusts are also valuable if privacy is important to you. If you prefer that the details of your estate remain confidential, a trust accomplishes that. If you have a blended family, minor children, or beneficiaries who may need protection from creditors or who might not be ready to manage an inheritance responsibly, a trust gives you much more control. You can specify exactly when and how distributions are made, perhaps in stages as a child reaches certain ages or with conditions attached. And importantly, a living trust provides for your own care if you become incapacitated. Your successor trustee can step in and manage your financial affairs without the need for a court-appointed guardianship and conservatorship. Here's something that surprises many people. Most comprehensive estate plans include both a trust and a will. Even when you have a trust, you'll typically also create what's called a pour-over will. This is a safety net that catches any assets you may have forgotten to transfer into your trust during your lifetime and directs them into the trust after your death. So it's not really an either-or question. It's about understanding how these tools work separately or together to create the right plan that protects you and your family. I hope this overview has helped clarify the differences between wills and trusts and giving you a sense of when each might be appropriate. The most important thing is that you have something in place. Too many families are left scrambling because a loved one never got around to creating an estate plan. Every family situation is different, and these decisions deserve careful consideration with a qualified professional who can understand your specific needs and goals. If you'd like to explore which approach is right for you, I'd be honored to help guide you through that process. Thank you for your time today, and remember to take care of yourselves and take care of the ones you love.